Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Welcome to AI Council Code. The AI Council Code is here to keep you up to date on all AI legal issues arising in the modern business frontier. I'm your host, Maggie Welsh, and today we're going to talk about AI and ethics. I'm joined with my colleague, Rich Harper, who's a partner in the New York office of Baker Botts. So, hi, Rich. Why don't you introduce yourself for the listeners?
Hi, everybody. My name is Rich Harper, as Maggie said. Maggie, thanks for having me today. I'm a business torts and contract litigator for technology and media companies. Here at Baker Botts, I'm the head of the New York office, as well as maintaining my practice. And in terms of the artificial intelligence issues that we're going to be talking about at Baker Botts, I serve as one of the firm's co-heads of our AI practice group, along with Maggie, our host today. Finally, I also teach a law school seminar on artificial intelligence in the law with a friend of mine, a colleague named Ben Odom, who is a lawyer at NASCAR.
Great. Thanks, Rich, for that introduction, and thanks for being with us today. I've heard you talk a number of times now on AI and legal ethics issues, but typically you don't just dive right into the legal ethical issues. Instead, you talk about the larger challenges associated with AI and how important that is. So, can you explain why you do that and why the larger challenges with AI are important to keep in context?
Sure. In one sense, legal ethical rules are all about risk management. So it's very difficult to apply ethical rules in a vacuum. In other words, without talking about some of the factual issues or talking about some of the risk issues of the underlying topic that you're looking to apply those ethical rules to. So what we typically need to do is explicitly talk about the risks created by technology or by lawyer conduct as part of looking at ethical rules. Getting practical, these legal ethical rules can be a little dry, especially if you read them out loud. Now, understanding again better the facts that you're looking at, it really just helps in terms of the application of the ethical rules. And so I like to talk about the concerns or considerations involved in any technology like AI before really digging into what could otherwise be seen as some relatively dry rules.
Fair enough. Fair enough. And so today's discussion, just to help put context on it, we're going to be focusing on generative AI because that tends to be the first way where most lawyers are consciously using AI and seeing AI come up in their daily lives. So, what are some of the primary challenges associated with generative AI?
Sure. There are a number of challenges, especially if you want to broadly define challenges to include things like public policy issues. But I do think there are some core things, core challenges that folks think about or that arise from any lawyer interactions with generative AI. The first is a lack of transparency of generative AI models. It's essentially the challenge of seeing behind the output that you're getting from a model, seeing kind of what's going on or understanding what data is being used and why. The second is the reliability and accountability issues that come with generative AI models. What we're concerned with there in terms of the reliability in practical terms is the accuracy of the output with respect to individual requests. And also over time, as you work with the generative AI model, finally, the third one I kind of think about a lot, and you can make a good argument that it's the primary concern, especially over time, is bias and discrimination issues that come with the output of the generative AI model. You have it where you can take all of your data that you train a model on, and you could have it be from, I don't know, information from the 1940s and how that data and how the model is going to give you output with respect to modern cultural issues could be kind of askew or it could be kind of different if it's based on data from the 1940s. So always thinking about bias and discrimination when looking at the output of a model. But those three concerns share a real need for the user of a generative AI model to have a good grasp of what the model's doing and how one can, in a really positive way, question or analyze the output that the model generates. Hope that helps.
Thanks, Rich. Let's get into the headliner of ethics and how some of these challenges relate to legal ethics and the legal ethics rules and how attorneys should be approaching generative AI in light of those ethics rules.
Sure. The way that I tend to approach it when we teach a class on this one or in talks with groups is starting off by understanding that a number of you listening will be in different states or different jurisdictions. And I think that the best way to approach the issue is to be talking about the ABA model rules of professional conduct. Those model rules have been adopted in whole or in part by all 50 states. And so I'll refer to those rules. And here in the context of AI, I found that it's pretty consistent from state to state. And so hopefully we'll be able to work off those and have kind of a consistent language. Now, the issue is how to apply a set of rules that have largely been in place for multiple decades in the case of the ABA rules for a new technology. But what we're doing is essentially here kind of the same thing that a number of you are doing as practicing lawyers on a day-to-day basis. So, for example, involving AI, patent lawyers are applying long-established patent law and statutes to whether AI, for example, can be an inventor. Or we're also, as practicing lawyers, applying copyright law that's been enacted from early in the 20th century to help resolve huge disputes over what information a generative AI model can train on. So the bottom line is you need to kind of approach these rules, understanding that they've been in place for a while and seeing how they apply to a new technology. And the rules here do, I think, a good job in the first instance of addressing these AI challenges we've been talking about. And I think of them as kind of a core set of 3 rules. The first is Rule 1.1, which is the duty of competency. As you'd imagine, it's about providing competent representation to a client. And there's a note that's known as Comment 8 that talks about the need to maintain requisite knowledge and skill, and that a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. And that's exactly what we're talking about here, Maggie. We're talking about duty of competency and your obligation as a practicing lawyer to understand the technology that you're working with. The second of the big 3 rules that I usually talk about is the duty to supervise. You're not only responsible for yourself, you're responsible for supervising associates or younger lawyers that you're working with who are using AI to understand what they're doing, how they're using it, and that they're using it appropriately. And that's Rule 5.1. in terms of the duty to supervise. And then the third one is Rule 1.4, which is the duty to communicate with your client. You have an obligation to communicate with your client regarding what you are doing. There's a comment that talks about the necessity to reasonably consult with your client about the means to be used to accomplish the client's objectives. And there have been debates that have been taking place as to whether we as practicing lawyers have an obligation to tell our clients the ways in which we're using artificial intelligence. Happy to get into that in more detail, but let's just say for this purpose, for this point, that you need to be thinking about it. What level of communication are you going to have with your client regarding how you're using generative AI? So those are kind of the big 3, Maggie, in terms of the rules. I'd also point out that a kind of a real good practical one is Rule 1.6, and that's the confidentiality of information. It's a real world example over the last 18 months because a number of practicing lawyers and just a number of folks out there don't understand that when you put confidential information of a client into that request box for a generative AI model, if it's a public version of the model, that confidential information that you're providing can be used for training oftentimes. And at least there is a theoretical possibility that data could show back up in the future for others who are using the model. And that's something that has become a topic of conversation, to be very cautious or very careful before you share confidential client information in at least a public version of a generative AI model. And that's really Rule 1.6. So that's kind of the core: duty of competency, duty to supervise, and duty to communicate, with a little bit on the practical issue of confidentiality, Maggie.
Important issues. Thanks, Rich, for walking through those. I think it's helpful for all attorneys to keep in mind as they work with generative AI more and more in their practice. And I think one area where we saw this come up recently was a real world example that most lawyers heard about through different outlets, where plaintiff's attorneys submitted a brief with a series of case citations that turned out to be generative AI hallucinations. Can you talk about that and some of the implications there?
Yeah, so that's typically referred to as the Avianca litigation. It was in New York federal court. A series of decisions were issued last year in 2023 regarding those hallucinations, or what the plaintiff's lawyer claimed were hallucinations generated by an AI model in terms of case citations that he relied on and included in a brief without going into and looking at those cases or reading the opinions before submitting the brief. And there are a number of things that are interesting about that case. One is that it is primarily talked about, known about, thought about as a sanctions case. It was a Rule 11 sanctions motion. A judge granted it, sanctioned a relatively small amount of money against the lawyer for the conduct in terms of relying on hallucinations without checking the cases that were being cited. My recollection, at least, is I don't think that the judge cited any ethical rules in going about issuing that opinion. But of course, that case and the conduct raise a number of those ethical issues, and primarily Rule 1.1, the duty of competency, and in that comment 8 that we were talking about a few minutes ago, to be abreast of technological developments. If you're going to use something like a new technology in preparing work that you're going to submit to a court, you need to understand what it does, what some of its positives are, what some of its negatives are before you start blindly relying on it. And what was interesting is that a number of the same concerns that the judge expressed in applying a Rule 11 standard are some of the same concerns that you think about in terms of a duty of competency analysis under Rule 1.1. So it's an interesting case, an interesting practical world example of the kind of interactions you can have with generative AI that you need to be cautious about, but also that it raises some interesting ethical issues at the same time as the sanctions issues that got reported.
And another real world example of AI impacting the legal practice that we've seen is a number of judges enacting rules to require attorneys to certify that they're using AI or how they're using AI in their work and in briefs that are being submitted to the court. So, what's your reaction to that, and how does that apply with a lawyer's ethical obligations?
Yeah, I think that it's a relatively limited number of judges who have enacted those rules of practice that require that if you're going to submit a brief that somehow uses or works with AI, that you're going to file a certification that goes with it. And I'm cautious about those rules and relatively negative. The reason I am is because I think that the rules of ethics that we've already been talking about in the form of the duty of competence, the duty to supervise, as well as you can argue Rule 11 itself do a fine job of putting in place kind of a common sense standard that we as lawyers have to follow in using the technology. What concerns me about those individual practice rules is that requiring you to fill out a certification if you're going to use the technology is going to discourage lawyers in that particular court from using the technology. It's just easier not to for that judge. It's easier not to for a court. If you're going about and just submitting briefs, it's less of a hassle and it's easier to just avoid using AI under those circumstances, which I think is exactly the opposite of what we should be trying to do, which again is trying to encourage folks to engage with the technology and do it in a responsible way. So whenever you've got a new case with the judge, look for that judge's individual rules, see whether or not they're talking about the use of AI and whether you have to do a certification and connection with them. But if they do, think pretty carefully about whether it makes sense to do that with that court or not. And hopefully, in most instances, the judges or the local courts have not imposed such a certification requirement because the ethic rules that are in place already should have it covered pretty nicely.
Great. Thanks, Rich. And any final words that you have for our listeners on this topic?
Sure. I think that when it comes to AI generally and talking with lawyer groups about it, the theme that I like to talk about or come back to time and time again is to engage with AI, but bring your judgment to it. And what I mean by that is I think a lot of us look at something like new technology, like artificial intelligence. We don't know where to start. And what I tell you is dive in, use it on a daily basis, use a generative AI model on a daily basis. Pick one. There's a number of them out there. They generally have free versions and use them. Use them to get a recipe for what to make for dinner at night. It doesn't have to be legal related, but you use it and move up a learning curve with respect to the technology. But then in addition to that, bring your own judgment as to what is a good case that's been cited. And whether there's a reasonable legal position that's being put forward and to be bringing your experience and your judgment onto the scene, that's invaluable in terms of using and working with generative AI. So again, I just leave everybody with the thought of engage with it, have some fun, use generative AI on a day-to-day basis, but don't be shy to bring your own practical experience to the scene to help make sure you're using it in a way that is correct and legally ethical as you move forward. Thanks, Maggie.
Thanks, Rich, and thanks for sharing your insights on this hot topic. And thanks for listeners who are listening to AI Council Code. We're so glad that you joined us today. Stay tuned for additional podcasts and more insights on AI legal issues from Baker Botts.
Thank you for listening to this BakerBots podcast. BakerBots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on BakerBots practices, please visit us at bakerbots.com. This presentation is provided by BakerBots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.